muted the entire time. Could anyone hear me?
I can hear you now, Judge.
Oh. Good morning, everyone. The 14B District Court is now in session. My name is Elaine Washington, and I'm the judge that will be presiding over this session. The court will call the case of the State of Michigan versus Jason Massey, 24S-00156.
Tiffany Woods for the people.
Good morning, Your Honor. Michael Vincent on behalf of Jason Massey. Mr. Massey, state your name for the judge.
Jason.
You muted yourself in the middle of stating your name, sir. Could you unmute and state it again?
My apologies, Jason Massey.
Thank you very much. All right, we're here today for a hearing in this particular matter. I did receive the defendant's brief regarding the issue of whether or not Mr. Massey was under or considered himself in custody or free to leave at the time of this the questioning, and so that's the issue before us today. We have made a record of the issue at the last hearing. Are you ready to proceed, Ms. Woods?
Yes, Judge, and I also filed a response to that.
I did not do that.
I sent it a couple days ago to Heather, 14B court. I CC'd Mr. Vincent on it.
Your Honor, we never got a brief from the prosecutor's office. All we received was a 2-page police report.
Judge, I sent that to I sent it to 14B traffic criminal Heather Ball and Michael at Vincent Legal Services. It was people's response to motions, defendant's motions to dismiss, and it was sent on Wednesday.
Thank you. All right, I do have my copy, and the reporter indicates that your email address is also in that particular email, Mr. Vincent. So maybe ask your staff to provide it to you. We're going to take about 5 to 10 minutes to take a look at that. I'm just getting my copy as well. So
All right.
About 5 to 10 minutes. Court be on a brief recess.
Tiffany.
All right, we took a moment in order to review the people's response to the defendant's motion to dismiss. Have you had a chance to adequately review that, Mr. Vincent?
Yes, Your Honor.
Mm-hmm.
And I have an objection to that report at the appropriate time.
All right, you may proceed.
The document that I just finished reading cites a lot of what Deputy Roberts had to say. Deputy Roberts never testified, Your Honor. I never had a chance to cross-examine Deputy Roberts. To put that in a motion or memo of law, I believe is inappropriate. I never had an opportunity to cross-examine. What I was doing was going through my notes. He never took the stand. The last thing I remember about the deputy, I asked him to be sequestered, and he was never called, to my best memory, and to all the notes I have. Secondly, there was an investigation going on of a serious charge, particularly in this county, of domestic violence. And even if he did testify, one of the questions I would have asked him is the whole, what were you doing? What were you investigating? What kind of charge? But I've never had a chance to cross-examine Deputy Roberts, and have no way to respond to whatever the prosecutor thinks Deputy Roberts may or may not have said. Also in the report, there is talk about a traffic stop. Typically traffic stops, which I'm well aware of what involves in a run-of-the-mill traffic stop. Yes, for a license or registration, typically people are speeding or going through a stop sign or a red light. And you don't have to read somebody a Miranda to get their driver's license registration. It's a very minor stop. No one's confrontational. You get a ticket. So this is not a traffic stop. It's not a Terry stop either. And Terry a 25-year veteran Cleveland detective noticed two people working outside of a jewelry store minutes before closing. Based on that training experience, he got out of his car and patted one of them down and found a gun. This is not a Terry stop either. This is a full-blown investigation that went on and put in there a minute and a half. This went on a lot longer than a minute and a half.
Well, I think, Mr. Vincent, she's referring to the statements that were made by your client, which she claims were, for the most part, volunteering. And they have a right to stop and see what's going on.
My issue with Deputy Roberts is I never got a chance to cross-examine the man, not
Okay.
once.
So-
And I'm frustrated by the idea that in the police report, I think it's at least 2 or 3 pages of what Deputy Roberts did, why he did it, all sorts of information, none of which I can challenge in cross-examination. And I don't think that's right to say, put in a report.
He's present today.
Yes, Judge, I thought that's what we were here to do.
Ms. Woods, 1 second. Go ahead, Mr. Vincent.
My understanding of the Miranda was an issue that was brought up the last minute by the prosecutor.
No, I brought up the Miranda issue.
Excuse me, well, Your Honor did. And then I responded to that issue. I did respond to whatever was going on with Deputy Roberts because that was never testified to. No issues were raised at the hearing about Deputy Roberts.
Well,
And
he's
for
a
the
part, he's a part of the, it was 2 people there. They're all there. So the question is whether or not that the entirety of that investigation was a violation of anybody's rights. It's not whether it was Trooper Varant or Deputy Roberts. It's the 2 of them together make up the entirety of the circumstances. But as to your issue of what was put into the memo, I mean, it wasn't written in a fashion where she said that she believes that the trooper will testify to X, which is how it should have been written. But people write that way, put what they believe the officer is going to testify to all the time. That's not abnormal.
What is being referred to in the memo, Your Honor, is the deputy's investigation, the deputy's police report, which we did receive. By the way, we never got the email on this motion or memo of law from the prosecutor. I don't know why, but we didn't get it.
Certainly.
On the last hearing, I asked for the deputy to be sequestered. Obviously, at this point, he hasn't been sequestered in the sense that he's been contacted by the prosecutor, and there's a report even made, I think about a week ago, by the deputy regarding 911 calls. I want him sequestered. Obviously, at this point, he's not sequestered anymore. He's here in court. Your Honor, may I address the court briefly?
You may.
The fact that I am agreeing to cross-examine the deputy, does that mean that I don't give up my argument by the sequestration? I want to preserve that argument.
It is preserved.
Thank you.
All right. Please turn on your camera, Deputy Roberts. The issue is more than just whether they had the right to interrogate him on the street or whether they did. There's a whole separate issue. But the question becomes, let's say that he made the statements as was written in the prosecutor's brief, and those statements come in. So at that point, do you both agree then that they get to do field sobriety tests? Let's say those statements come in. That's my hypothetical question.
Your Honor, could you repeat that, please?
Let's say everything that let's say the testimony comes out just as Ms. Woods wrote it in her brief. And I rule that it was not a custodial interrogation at that point. The question becomes, was he free to leave then or not? or did he have to be read his Miranda rights before they made him take the field sobriety test? In my mind.
And Judge, that's why I believe we're here today. And I believe he was not in custody. There was not a custodial interrogation at that time when he made the statements that he was driving that vehicle.
No, you're not hearing my question. Let's say he wasn't in custody at that time. Is he in custody when they start to make him take tests?
Well, I didn't print the case law, but I did read some case law on that they say that it wouldn't matter if he was in custody or not during field sobriety tests because that has to do with movement. And I don't have the exact language, but there is case law on that where whether they're considered in custody, even if they're considered in custody at that point, they're doing tests. So it has to do with movement.
That's if he's driving. That's not if you just stop somebody on the side of the road who wasn't driving.
What do you mean? I guess I'm a little confused.
Well, if you stop someone on the side of the road and they're driving, you have a right to do that. That's the exception. But this doesn't fall within that exception. So how do you get to having him do field sobriety tests? Why don't, and this is my question, isn't there a requirement that if in this particular circumstance, which I ruled it is this particular circumstance, he then needs to be advised that he's under arrest and he has a right to take these tests or not take these tests?
He and that happens, Judge, that when does the field sobriety test, but the field sobriety tests don't happen until there's reasonable suspicion that he's been drinking and he's been driving. When he made those comments to the officer, then the officer now is developing reasonable suspicion that he was under the influence when he was driving, and then he's asked to take the field sobriety test.
I understand they asked him to take the test. You still haven't addressed my issue.
I guess I'm confused as to, because what we're here today for is, what I thought we were here today for is the comments that he made about driving that vehicle.
I never said that. I never said that. That's how you defined it. As to the comments on.
We froze.
Testing. We're back up, Your Honor. I apologize.
Actually, I didn't freeze. She said stop because the recording stopped recording, and so I stopped.
My brain is freezing right now. It's 19 degrees out.
So I never said that was the only issue before this court. What I said was suppression can occur if his rights were violated under Miranda. And I didn't say as to statements only. I said suppression can occur. So even if I ruled that his statements come in, I don't know how you personally get to the fact that his field sobriety tests come in or his results from any of that if there's a violation of Miranda. And I'm not saying there is yet. What I am saying is, how do you get to that?
Judge, if you're going to rule that he was in custody, there's case law out there that says that field sobriety tests are not akin to being questioned. I mean, it's on a different level.
So that's when the person is driving. That is true. It's an exception. That is not true under these circumstances, Ms. Woods.
Judge, from what I guess I'm a little bit confused by what you're saying, but they can develop reasonable suspicion.
Yes, they can. And if they arrest him, they have to read him his rights. In this scenario, because he's not driving, the exception for field sobriety is when people are driving.
Well, he admitted he was driving.
When they see him driving, they stop. It's a stop Okay, thank you. Mr. Vincent, do you have anything you want to add?
I think Your Honor has touched on the issue exactly how I feel about this case. This is a highly unusual set of facts. This is not a typical traffic stop on the roadway. The officer asks the person to get out and do a field test. This is not what we have here. What we have here is starting with a serious possible criminal charge of domestic violence or more, some type of assault or crime, excuse me, that morphed into this trooper starting an investigation without reading his Miranda. He didn't see him driving, he wasn't in the car wasn't running. None of the typical street stops for drunk driving apply in this case. He should have read him his Miranda, in my opinion, before anything got going. And he clearly wasn't free to leave.
All right, let's take this.
I said four, there was four, actually I counted wrong. I think there's 5 or 6 officers there. Almost a police convention.
And they all arrive after Mr. Vincent, after the remarks are made. So I guess the court needs to decide if a court's going to decide that he's in custody, at what point is he in custody? Because I don't believe that when he made those comments to the police that he was in custody. If it ends up being developed that he was in custody at some point, it wasn't at that point.
Anything else, Mr. Vincent, before we bring the deputy back in?
I believe when the deputy arrived that this was a custodial situation.
I understand your argument.
And it went all, and I totally agree with the court's statement that I feel if he's going to investigate something, he's got him right in front of him. I sent a picture, as a matter of fact, there was 2 state troopers, one trooper variant, another young trooper in the picture. So he was there, cops were everywhere. There was at least 2 officers to begin with. And this morphed into an investigation that had nothing to do with the traffic stop. Nothing at all to do with the traffic stop.
All right, thank you. Let's bring the deputy back in. All right, Deputy Roberts, you are under oath and it is your witness, Ms. Woods.
Thank you, Judge. Good morning, Deputy Roberts. Could you please state your name again for the record?
Deputy Greg Roberts,
And where are you currently employed?
Washtenaw County Sheriff's Office,
And in what capacity?
as a deputy canine handler.
Okay. And were you employed with and working in that capacity on March 17th of 2024?
Yes,
And were you involved in an investigation involving Jason Massey?
yes.
Okay. And where did that investigation take place?
It was westbound I-94, just before or at the Michigan exit.
And is that a public roadway?
Yes,
Okay. And what did you observe? First of all, you were driving in that area. Isn't that around that area?
yes, I was driving by.
Okay. And then did you observe something?
Yes.
What did you observe?
I observed a newer Ford Bronco parked on the side of the road. I also observed 2 subjects rolling around on the ground off to the side of the vehicle in the ditch near the wood line.
Okay. And is this before you got any calls from dispatch about what was going on?
Yes, yes. I asked him.
I'm going to object to anything he said at this point, Your Honor. The deputy just said he was investigating an assault. But just finished saying that. There's 2 people rolling around on the ground, gets out, deputy gets out of his car or by the car, pulls up to them, separates them. It begins an investigation for an assault. Should have read his Miranda then. When he started questioning him.
Got him.
Judge,
Ample opportunity to read the Miranda. He separated them. One is several feet away from the other. He starts talking to Mr. Massey, investigating a crime, investigating an assault. Minimally, a domestic violence assault. Could be more. But he's investigating an assault. Never read him his Miranda.
Judge, Miranda would not be in, he was not even in custody at this time. This is a preliminary investigation. Officers have the right to come on a scene when they believe there may be a probable cause that criminal behavior is afoot. They don't have to Mirandize. Mr. Vincent makes it sound like every single time an officer comes into contact with someone that they have to immediately Mirandize them, and that's not the law.
I did not say that, Your Honor. I did
Judge,
not say
they
that.
have,
I did. Please.
I'm speaking.
finish.
Can I please make my argument? That
sorry.
from what we have here is we have an officer, first of all, he didn't pull the vehicle over. The vehicle was already pulled over. He has a right to now do a preliminary investigation. They're not in custody. There's nothing here that shows that he was seized at this time. The officer has a right to ask investigatory questions. He's not in custody. Miranda is not necessary at this point, Judge.
Thank you. I agree with the prosecution that the Miranda had not been required at that time. You may proceed.
And then when the defendant approached you, did he make any comments to you without you asking him anything?
I believe so. I would have to review body cam for the exact statement.
He actually physically takes his license and gets into his police car and then runs his information. That's after all the questions are done.
He has his license the whole time.
Not at first, he doesn't.
He asked him to give him his license. He goes into the car. He gets his license. He hands it to the trooper. The trooper then takes him back to the vehicle while he has his license in hands. Miss Woods, I watched the video.
Right. And that's something you look at, but in traffic stops all the time, Judge, where they're not considered to be in a custodial interrogation, officers take...
Stop. We're talking about this case. This is not... Stop.
Well, so, I mean, we're basing, when I read other case law, they say that there are a bunch of factors. And in traffic stops, that it's very common for the officer to take someone's license and run their license and registration because the officer is going to eventually give that license back. It's not like Trooper Brandt took his license and left with the license or refused to give his license back to him, Judge. That never happened.
Right.
And it's very common for officers when they're in a traffic stop to take someone's license, run the information.
We keep talking about hypotheticals that we're not talking about. And so you can keep doing that. It doesn't confuse me in case you think it does.
I'm not trying to confuse you, Judge. I'm just trying to relay what I read in case law.
Not about this particular situation, as I've said like 5 times.
Okay. So he did take his license, Judge, and he did run his information and you don't see in that video, but he does get his license back. Officers, others things that they look at is how many officers were there. At that point in time, when Officer Roberts was there, he was the only officer. There was no other officers there. That was a very, very brief questioning that only lasted for, I believe, about a minute and a half. There's no weapons were drawn. There's no threats. And then when Trooper Brandt arrives, that's only the second officer. And again, there's no other officers during that time period that are there essentially a show of force with weapons that would make the defendant believe that he was not free to leave. Whenever he was made those remarks, those admissions to both of those officers.
There's no admission for the deputy.
The defendant was never threatened. He was never removed from the scene. He was never placed in a police car. There was no physical touching. There was no intimidating language. They never restrained his movement. All of the things that you would find when someone is in custody didn't happen in this case, Judge. So whenever Mr. Massey made these admissions to both Deputy Roberts and Trooper Brandt,
I'm going to object Your Honor, I'm going to object this point about deputy.
I'm trying to make my argument.
I'm sorry, but you keep mentioning what he said to Deputy Roberts. There was nothing on the tape.
There is there is the remarks that he made. We all listened to it. It was in evidence. He did make remarks that he had to pull over. Those were remarks that were made. He told Deputy Roberts that he had to pull the vehicle over. At the time that these
Your Honor, I thought Your Honor
Judge,
made a ruling that's just about Trooper Brandt. Now we're into Deputy Roberts. I am frankly.
No, I did make a ruling regarding Trooper Brandt. I asked her questions. So let her finish her arguments and then you can argue about what you think. Please let me finish making your ruling.
Shut up.
You can
my whole point, Judge, is that at the time that Mr. Massey...
My ruling, please.
Oh, I thought you said to let me finish.
No, I did. And then you interrupted as I was finishing my ruling. And I said, for you to let me finish my ruling. And then you interrupted me again. So,
I didn't. Sorry, Judge. I wasn't aware that I interrupted you. So go on.
Oh my God.
Mr. Vincent, any arguments that you have regarding what statements she's making, you can make them during your argument. I'm going to need the two of you to stop interrupting each other and arguing over each other. The recorder cannot distinguish who's saying what when that happens. Ms. Woods, please sum up your argument, please.
Yes, Judge. My point being is when Mr. Massey made these voluntary admissions to both the deputy and the trooper, he was not in custody. There was no custodial interrogation that was happening at that time. Therefore, Miranda would not have been necessary at the time that Mr. Massey made those admissions to either Deputy Roberts or Trooper Brandt.
Thank you.
Thank you.
Mr. Vincent.
Yes. This is not a traffic stop. This is not a Terry type of stop. This was something very unusual, different set of facts from a normal drunk driving investigation. We started with some type of assault investigation and morphed into an investigation regarding driving while intoxicated. The only exceptions to making an arrest on a 93-day misdemeanor is if there was an accident or probable cause. There simply has been no probable cause provided to this court. And the only thing that's been relied on is some type of statement he made. I have argued in my memo of law, I'm arguing now, that, and I'll use Trooper Variant's words, what would happen, to my question, what would happen if before everything started going, if he tried to leave? And he would have been, the trooper clearly stated he would have been stopped. He wasn't free to leave. If he's not free to leave, you got to read him as Miranda. I cited a case, Villa versus Gonzalez. Similar situation. Guy was on his front porch and an investigation went on. And I do agree that initially there was 2 officers there, but I provided a photo of another state trooper there right around the same time, another deputy. There was at least 5 to 6 officers showing up periodically. He was not free to leave. It's a custodial situation. Whatever he said has to be thrown out, and there's no probable cause for an arrest. And by the way, I'm sorry I interrupted. I should not do that. Interrupt the prosecutor.
Thank you. All right. In this particular situation, I've listened to Deputy Roberts and Trooper Varant's testimony. I've watched the video, and I have to acknowledge that some pieces of it were garbled, and I couldn't make out what everyone was saying. My analysis of this, though, relies on more what the officers were saying, and the two of you can figure out what was said at what point from the defendant by watching a video that shows his statements more clearly. The reality is that the initial stop, I disagree with the defense. I believe it was a Terry stop. I believe they do get to ask questions. Deputy Roberts, when he arrived, did have the ability to ask questions. He saw something going on, people rolling around on the ground. He had the ability to stop and ask questions. Any statement that defendant made to Deputy Roberts is considered a part of a Terry stop. When Trooper Varant arrived, he then had the opportunity to come over and ask the defendant to provide a copy of his license, which he did. And anything that was said to Trooper Varant, prior to the time that he hands him the license is a part of a Terry stop. Once he hands him the license and essentially directs him to the car, to the trooper's car, and is holding on to Mr. Massey's license, it is my ruling that the circumstances at that time, including the way the cars were parked, including the way that the defendant was ordered, directed in some way, shape, or form to go back to the trooper's vehicle. The fact that the trooper had his license at that time, the fact that there were 2 police officers, deputies, troopers on the scene, I believe that no reasonable person would have felt free to leave, and that any statement made once he gets back to the car is considered part of a custodial interrogation. So anything that occurs after that is considered a custodial interrogation. That is what my ruling is. There's no debate from either one of you about it. You can appeal it. You don't like it, that's on you. But that is what my ruling is, and it's up to the 2 of you to determine what was said at what point. And I don't know whether or not the prosecution will be able to proceed or not, but anything after that point is suppressed.
Thank you, Judge. And I will be proceeding with this case. I don't want it to be dismissed based on that. I know because the defense counsel wrote, his motion was for the case to be dismissed.
I understand what you want. The only issue is what was said and whether you have enough evidence to move forward or not. And I can tell you, if you're moving forward on something that you can't prove, I am going to assess costs.
Judge, I have a witness. I have potentially 2 witnesses, but I've got Mr. Massey's passenger that was in the vehicle with him that I can call and have her testify at trial. So I believe, and I also have a 911 caller that also described Mr. Massey in his vehicle driving erratically right before the stop was made. So I believe even if I move forward with just the statements to Officer Roberts, I believe there is enough evidence to
So
go
you
forward with this case.
Oh, you believe statements I don't know what the statements say. I don't believe that's when he made the statement that he was drinking too much, but I don't know. I don't even think
Well,
that's what,
I just need to put him behind the wheel, Judge. I mean, the fact that he admits that he's drinking or not doesn't mean anything because I have
right,
blood result.
you don't, because that's suppressed.
What's suppressed?
Why is that not suppressed?
His blood results?
Yeah. Anything that happens after the trooper arrives there is suppressed. I just said that.
Oh, I just thought you said his statements were suppressed.
No, I did not say that.
Got it. Thank you, Judge.
Your Honor, again, this matter should be dismissed. There simply is no, based on Your Honor's ruling, there is no probable cause.
Mr. Vincent,
Yes,
I
Your Honor.
don't know what was said at what point. I can't even hear it, as I said earlier. So the two of you need to figure out what was said and what she actually has. She also is indicating that she has a witness who maybe she wants to proceed with that. I can't dismiss the case if that's what her proofs are. She has witnesses that saw him driving that she's bringing in. I can't dismiss her case. That's not how this works.
But you're suppressing his breath test and his blood test?
Unless you had a court order for that, correct. If you had a court order, that's different, but you can't use a blood test where I just said that everything that comes after that statement is suppressed. I don't know if you got a court order. I'm not looking at that part of the case. That's your case.
All right. Yeah, Judge, I'll have to take a look at it then.
Mr. Vincent? Is there a court order?
There's no court order.
Okay. Well, anything after the fact that he's taken back to the car is suppressed. Any evidence, any statements, all of it is suppressed. Please prepare an order to that effect. The prosecutor just decide whether they're able to proceed or not based on that.
Thank you, Judge.
I will present an order to the court, Your Honor, and to prosecutor.
Thank you.
Thank you.
Thank you, you guys. Have a